Did you see that instant reaction? Instead of addressing what's being said, her first concern is the fact she's being recorded, like the lens is more threatening than the truth itself. That kind of response? It speaks volumes. When someone's priority is stopping the footage, you can bet there's something bigger simmering beneath the surface. And let me tell you, this isn't your run-of-the-mill courtroom dispute. We're talking about serious accusations here. Whispers of people being held against their will, gates locked tight, and even claims that a maintenance worker was stuck inside a sweltering townhouse during extreme heat. This is one of those cases where every detail feels more intense than the last. So buckle in, because what's unfolding in court is anything but ordinary. There's suspense, sharp turns, and a legal showdown that's keeping everyone on edge.
What is this? Are you recording?
You want me to take it out?
Please.
The recording, yes.
Okay.
I didn't see that part.
All right. Good morning, Ms. Abbas-Yelling.
Hi, good evening.
So you're telling me that you have a lawyer.
Yeah.
Who is your lawyer?
Attorney Rehan.
Who is it?
Rehan?
See if they filed it. Do you know if this person is going to show up today?
Yeah, he's there.
Okay. We're just going to do probable cause now. You now are charged with unlawful restraint.
Let's pause and really break this down, because what just happened in that courtroom carries serious legal weight. The judge has formally announced the charge, unlawful restraint. Sounds technical, right? But here's what it means in simple terms. Someone is being accused of stopping another person from leaving without any legal right to do so. That's more than just a misunderstanding. It's about control, restriction, and potentially crossing a big legal line. And since this is all playing out in Texas, the consequences are no joke. We're talking about a possible jail sentence of up to 12 months, or a fine that can hit $4,000. That's not the kind of penalty you just walk away from. Whether this stems from confusion, poor judgment, or something more troubling, the courtroom is now dealing with a criminal accusation that could change lives. The tone just shifted, and things are only getting more serious from here.
You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford a lawyer will be appointed to represent you. We will do this now, and then after that, we will just have you wait right over there for your lawyer to come. Hopefully they will show up. Okay, I love it. Good morning.
On August 5th, 2024, officers were dispatched to a hostage event at a townhouse in Harris County, Texas. The reporting, who is the project manager of the townhouse complex, called 911. The reporting indicated that the defendant was wearing an all-black religious garment and had a face mask.
Now picture this. According to the allegations, she didn't just show up. She arrived in full black attire, her face completely concealed, like something straight out of a suspense thriller. It wasn't just a visit, it was an entrance meant to send a message. Things escalated quickly after that. She's accused of repeatedly cutting off both the power and water to a tenant's home, deliberate moves that go way beyond your average property dispute. But it doesn't stop there. When a maintenance worker reportedly stepped in to help, things took an even darker turn. He claims he was suddenly trapped inside the very townhouse he was trying to service, locked in behind heavy-duty metal security bars. Not just a safety hazard, but a terrifying moment of helplessness. At this point, we're no longer talking about a civil disagreement between landlord and tenant. This is starting to look and feel like calculated intimidation, an alleged campaign of pressure that's unfolding in the heat of day. And with rising temperatures outside and intensifying legal pressure inside the courtroom, this case is reaching a boiling point on all fronts.
She had locked one of his employees, the complaining witness, inside a townhouse against his will. The reporting advised that the defendant was trying to evict a witness, or trying to get a witness to self-evict. She was trying to get the witness, who was her tenant in the townhouse, to self-evict by shutting down the power and water to the unit repeatedly. The complaining witness, who was the maintenance man for the townhouse complex, went to go check on the tenants to see if they were okay. The reportee indicated that the defendant locked the steel gate, which would not allow the complaining witness to leave. They had a key lock on the front and key lock on the back side. The tenant did not have the key to the back side of it, so if she locks the front, there's no way to pass through the gate.
Okay, so the unlawful restraint is out?
Yes, Your Honor.
Outside?
It's a gate, and then it has, like the gate in the porch, on the porch, like a burglar gate.
Okay, so I'm assuming, so here's the door, and then you have, I guess, what, like those black burglar bars that they say.
Yes, Your Honor.
So he couldn't get into the house?
He couldn't get out of the house.
And he couldn't
She
get
locked
out.
him in the house.
Let me throw a question your way. Just imagine this. You're trapped inside a home. No air conditioning. No lights. Both exits sealed shut with locked gates. And then, someone outside makes a gesture, one that looks an awful lot like they are signaling they have a weapon. You'd panic, right? It sounds like something out of a thriller, but according to the maintenance worker, that was his reality. This isn't just an inconvenience, it's a chilling scenario. The kind that leaves you wondering, was this an act of pure intimidation? A massive miscommunication? Or are we looking at something more sinister and deliberate? It's the kind of case that sparks debate and divides opinion. So we're asking you, what do you think is really going on here? Is this a legal misunderstanding taken too far, or a dangerous crossing of the line? Drop your take in the comments, because this one is raising serious questions, and not everyone sees it the same way.
Without electricity or air conditioning.
And no back door to get out? No window? I don't understand.
We're getting there, Your Honor. When officers arrived, they spoke with the complaining witness, who said that he escaped 5 minutes prior, and the defendant and the witness were still inside the home. The complaining witness reported the house was really hot because the air conditioning wasn't on. Complaining witness stated the back patio door was also locked, and the defendant had locked him in. The defendant had made a motion at the time to her purse, which the complaining witness believed, or which made the complaining witness believe that she had a gun. The witness corroborated the complaining witness's story. And
I don't understand how this person cannot just unlock the door and leave from...
It was locked. It's so the doors, instead of having a push button on one end and then a key lock on both sides, on the other side, it's a key lock on both sides.
Now here's a legal twist that could easily get overlooked, but it might speak volumes. We're talking about the use of double-key deadbolt locks. You know the kind, where a key is required to open the door from both the inside and the outside. No push-button release. No quick escape. And in most places, especially here in Texas, that's a direct violation of fire safety regulations. Why? Because in an emergency, it can trap people inside with no way out, and that's exactly what this maintenance worker says happened. He didn't just notice it, he called it out himself. That kind of lock setup isn't just inconvenient, it's dangerous. And while it may not be the headline charge in this case, it adds a new layer to the story. It suggests a level of recklessness, or possibly intent, that turns this from a messy dispute into a potentially life-threatening situation. So, while everyone's focused on the main criminal allegations, keep your eye on these smaller details. Because sometimes, it's the overlooked elements that reveal the true depth and danger of a case.
Both
sets the doors, Your Honor, which the maintenance man, the complaining witness, indicated was a violation of the fire code.
Well, that's neither here nor there, but doesn't this person have a master key? Or I guess this is a residence, right?
He doesn't have a master key, Your Honor. He's the maintenance man for like the condo association. So he maintains the condo. Each of the units has its own keys.
How long was allegedly stuck in the house, and how did he get out? This is unusual. And why? Was there did this, well, I guess...
He was attempting to turn the power and water back on in the unit because she has been repeatedly turning off the power from the tenants who live there. He told her repeatedly that he wanted to leave.
So presumably she's outside at this time?
She's in there with him, Your Honor. She asked him to sit down on the chair. There's a video that shows complainant asking defendant to let him go multiple times, and with her telling the complainant to shut up. I don't have the means by which he had left the apartment, Your Honor. I just know that he got out at some point.
This is where things take a serious turn. According to official reports, the maintenance worker manages to escape the townhouse just 5 minutes, yes, 5 minutes, before officers arrive on the scene. That's not just close, that's razor-thin timing, the kind that makes you wonder what might have happened if help had come just a little later. And here's where it gets even more intense. There's alleged video evidence. Footage that reportedly shows the worker pleading to be let out, visibly distressed, while the defendant can be heard telling him to shut up. That's no longer just a dramatic moment. That's a clip that could carry serious legal weight, potentially unraveling any defense based on misunderstanding or miscommunication. What's crystal clear now is this. This case isn't relying on just conflicting testimonies or courtroom speculation. It has visuals, on the record, time-stamped proof that could tip the scales entirely. When video enters the courtroom, it often speaks louder than any witness ever could.
In fact, he got out 5 minutes before the officers arrived.
So he was able to leave 5 minutes before the officers arrived?
Yes, Your Honor.
Did she let him go?
So it says, for the OR at least, the duration of time, I know that was asked, was an hour and 20 minutes. I'm gonna see how he left. I'm trying to read through the OR to supplement your questions, Judge.
I don't know if I'm ready to rule yet. Ms. Agbacieli, are you sure that you're going to have a lawyer here today? Because I'd like to hear your side.
My lawyer, yeah.
Um,
Attorney Rehan, yeah.
I don't want to rule just yet, but I'd like to hear your side. If there's,
I'd like to be silent. I'd like to wait on my lawyer.
well, right, I'm right, and I'm not asking you to say anything now. When that person gets here, then you talk with them, and then we can
Yeah, sure.
readdress
Yes, sir.
PC at
Yes,
that.
Your Honor.
So, do you mind just taking a seat for me and then just giving us a heads up when your lawyer comes? Come, Ms. Agbacieli, come up, ma'am.
I explained to her the no contact there.
Okay, great. Okay, I am going to find that there's
So here's the verdict at this stage. What did the judge decide? After hearing the details and reviewing the evidence, the judge rules that there is probable cause to move the case forward. In simple terms, that means there's enough credible evidence to justify continuing legal proceedings. The case isn't being dismissed, it's gaining momentum. But here's the twist. Instead of sending the defendant straight to jail, the judge sets her free under strict bond conditions. We're talking about a firm set of boundaries: no weapons of any kind, zero contact with the alleged victim, and absolutely no new criminal activity. It's the court's way of saying, you've got one chance, don't blow it. This isn't leniency, it's a legal tightrope. One wrong move, and she's headed straight back behind bars. The judge plays it balanced, firm but fair. She's offering a shot at freedom, but it's a fragile one, held together by rules that can't be broken. The message? You're walking a razor's edge now, and the courtroom will be watching every step.
probable cause to go forward. If something develops in the future, I have told that you guys can come back and we can argue about probable cause. The only thing I'm going to ask you is please do not have contact with the complaining witness in this case, and don't be in possession of any weapons. As long as you can abide by these and you do not pick up any new cases, you will be fine with us. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but please stay in contact. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant. Okay? Do you have any questions? Okay, so just no contact, no weapons, and that's it. Okay?
Thank you, Judge. Thank you.
Okay, thanks.
Just to go back to the body cam issue itself, right? The body cam issue itself, like, say if I were to file a motion to restore property or return property, it's been tagged, so I don't know how we're gonna.
I mean, I don't think that you would have any opposition to that, would you?
I do, at this juncture, I think Pavel said the body cam, like to retrieve her body cameras from HPD evidence.
For the motion to restore, Judge, I just need to talk to the investigator and see if we're retrieving it anyways.
If you're what?
If we're gonna retrieve that footage to make it available. I think we're already in the process of doing that. That's the only thing that's holding me back. But right now, I'm objecting because it's a part of a pending investigation. At this point, I just need to confirm it with the investigator.
Do you want to set it a couple weeks just to see if that happens?
Yeah, I mean, I really just need a week, but yeah, a couple weeks. would be
Are we
great.
judge, because like I said.
I'm waiving her appearance.
Oh, absolutely.
So, I mean, she's not gonna have to come here, so
2 weeks would suffice, Judge.
whatever you want, I don't care. Yeah, because you guys fight over whatever day, and then, I mean, if you want to, I'll grant your motion to get it back, though.
Yes, sir.
If they're not gonna get it back first, so.
Thank you, Judge. Thank you. Have a week.
Good morning, ma'am.
Hi.
Just a little bit down so I can see your eyes. That's okay. How are you?
Good.
Just when it seems like the courtroom fireworks have fizzled out, boom, another charge lands on the table. The same woman is now facing a brand new accusation, and this one takes a strange turn. She's alleged to have made a terroristic threat, and the details are straight out of a bizarre scene. According to the complaint, she pointed her fingers like pretend guns at two workers fixing potholes and told them, "I'm going to shoot you." Yes, over potholes. In a parking lot. You heard that right. Now, whether that was a poorly judged outburst or a real act of intimidation, the justice system isn't laughing it off. In the eyes of the law, threats, even if made with gestures, can be taken seriously, especially when they cause fear or disrupt public peace. This charge alone carries the potential for up to 6 months behind bars if proven. So while the puddles may have been small, the legal storm they triggered is anything but. This case just keeps escalating, and with every new development, the tension in and out of the courtroom continues to build.
Ma'am, you've not picked up another case. You're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. If one will be appointed to you.
Judge, if I could just confirm the name.
Agbasieli.
On April 1st, 2025, a law enforcement officer was dispatched to a residence in Harris County, Texas regarding a disturbance. Law enforcement officer made contact with the second complaining witness who stated that he was inside the apartment when he heard the first complaining witness outside getting yelled at by the defendant. The second complaining witness went outside to see what was going on. The defendant yelled at him to stop putting things in the pothole in the parking lot. The second complaining witness told the defendant he was fixing the hole. And the defendant then threatened both the complaining witnesses, pointing at them with their fingers, making a pistol shape with their fingers, saying, "I'm going to shoot you."
Wait, you said there were two complaining witnesses?
Yes, Your Honor.
Okay.
That's what I have here. It says, "I'm going to shoot you," towards both complaining witnesses.
And we have Ms. Agbasieli making the alleged threats?
Correct, Your Honor.
Your Honor, there's only charges one.
There's only, yeah,
Right.
yes, Your Honor.
Okay, who is the complaining witness?
Theo Strong.
Is it a known person? Because we have priors with Ms. Agbasieli and there are assaultive and, pretty dangerous priors. Any of the same complaining witnesses?
Does not appear so, Your Honor. I'm looking through. No, Your Honor. It seems like it's just, from what we can see, it's kind of just.
Was it a street worker? Was it someone working for the city or
It's someone that lives there, Your Honor.
just out there fixing the potholes?
That's correct, Your Honor.
Okay. All right, Ms. Agbasieli, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. Do you understand, ma'am?
Yes, Your Honor.
Okay. Do you have the ability to hire a lawyer, ma'am?
Yes, Your Honor.
Okay, we can give you time. So what I'll have you do now is I'll have you sign a receipt of victory while you take a seat, while we draft the bond conditions, I'll have you sign it, and after that, you'll be free to go.
Yes, Your Honor.
Please, ma'am, don't pick up any new cases. Just don't have contact with these people. I don't want to have to put you in jail,
Your Honor, it was the same thing the last time, the
Just,
last case.
just please be careful,
Yeah.
Really.
People make false allegations all the time.
And I get it. There's always two sides to the story. That's why you have a lawyer. That's why we'll give you time. But the evidence will point to whose side is correct.
Yeah, and I do have them.
So please.
Thank you.
Yes.